Hello and welcome to the fifth installment of the Weltman What's on Tap series. Today the topic is collection of deceased accounts, the forgotten strategy to enhance your recovery. This is a topic that sometimes you don't want to necessarily think about as it involves the death of a person, but it is also an area that frequently comes up with a lot of questions on how to best handle those issues. As you can see, there has been a coup. Mike has been replaced as the host of this episode. Unfortunately or fortunately, you are stuck with me. I'm Scott Best. I'm an attorney with Weltman. I handle New Jersey and PA. I'm also here with Cam Dean and Andy Condyles, both of which are licensed in both Pennsylvania and New Jersey. As a reminder, these are interactive sessions, so if you have any questions, feel free to submit them. If we don't get to them during the recording of this episode, we will certainly respond within 24 hours once you send over the questions. There will be a PowerPoint available that you're able to collect, as well as a survey at the end. We would just ask that you complete that survey so we can improve on these going forward. As has been the case, the topic that we've talked about, or the introduction, has been with regard to beers that we've liked, beers that we're enjoying now. And so Andy has a beer he would like to discuss today.
Absolutely, thank you.
All right. This is Craggle. It's kind of more of a citrusy IPA made by Free Will Brewing Company. You happen to be in Western Bucks County, definitely stop by Free Will Brewing Company's tap house. It's definitely worth the visit.
So as I mentioned in the introduction, the topic of today is the collection of deceased accounts, an inevitable thing that happens in the course of lending, that someone who you had a loan with, someone who had a credit card with your bank or credit union, passes away with a balance outstanding. So, Andy, the question that most commonly comes up is, what happens when you find out someone passes away? What's the initial process?
Yeah, without being too crude, I mean, the first thing you want to do is confirm that this person actually passed away. The best way to do that is to get a death certificate with a raised seal. Most municipalities issue like literally 25 of them for free, so it shouldn't be much of an issue for the decedent's family to get you one. If for some reason you can't get a death certificate with a raised seal, try Google the person's name and to look for a death notice or an obituary. If the date of birth on the death notice or obituary matches what you have, the name matches, and the address matches, be pretty confident the person's actually passed away. And once you've done that, you want to kind of inventory their accounts. You kind of walk through some of the primary types of accounts and how that pertains to the collecting on a deceased person. So if it's a single account and the deceased person is the only account holder, then you go ahead and reach out to the person handling this person's estate because they're the only person that had ownership of the account. If it's a joint account, let's say John Smith and Mary Smith are on the account. If John Smith dies and to your knowledge Mary Smith is still around, then the account becomes sole property of Mary Smith and there's not much to be done. If you have an account that's a payable on death account, this is a type of account where a depositor or funder indicates that they're going to give the amount of money in the account, or the money in the account to someone else once the funder passes away. The thing to watch out there is this gift, if you will, can be revoked at any time, and the asset itself, the bank account itself, is property of the person who was funded the account. So if the beneficiary dies before the funder or depositor, the funds simply stay with the funder. If the funder dies before the beneficiary, then the funds obviously go to the beneficiary.
And so what about in a situation where it's a husband-wife situation, the account's in entirety is an account, a joint account, husband and wife account. Does the bank have any recourse on that, or does it automatically just flip over to the wife and she's the one who's now the holder of the account?
So the situation where it would flip over to the wife. However, if the debt is in both of their names, some of the other collection remedies we discussed before, when it comes to bank attachments, are still things that can be explored.
And so you find out a person's deceased, and what do you look at, or what should the bank review to try to determine, is this even a collectible account? Is there a reason to engage either an outside law firm, internally try to review? What should the bank, or should the institution look into to determine we need to move forward, we need to file a claim on this?
Sure. So what you want to do is look up to the best you can, figure out how much they owe, and also figure out, again, to the best you can, how much they have. And I'm stating the obvious a little bit here, but the more money someone has, and the fewer debts that you know if they have, the stronger likelihood that this is going to be worth pursuing. And again, conversely, if someone's got a lot of debt and not much in the way of assets that you know of, it's less likely to be worth something pursuing. So again, it's strictly a business decision based on what admittedly is imperfect information.
And so you make the determination, this is something worth pursuing. Are there deadlines that are applicable to how long you have to notify either the estate representative, the executor? What timelines are we looking at in those cases?
So I think we're going to kind of go through the mechanics a little bit more of this later, but you want to file a claim in New Jersey, it's 9 months from when the person actually died. So if you find out they died 7 months beforehand, you now only have 1 month to file that claim. And New Jersey, same sort of calculus in terms of you need to file the claim. You've got only a certain amount of time, and the clock starts ticking when the person actually died. But in Pennsylvania, it's a 1 year time period. So if you've got the person died 11 months ago, Pennsylvania, you've only got 1 month to go ahead and file that
So
claim.
it's not a situation of the institution is only notified, they're notified on month 9 by by the estate representative. In New Jersey, you might be out of luck depending on the timing. Pennsylvania, you have a little time, but you really have to jump on it.
Correct. Yes. Then again, as you mentioned, the key thing is the clock starts ticking, to be crude, but the day the person dies, not when you find out about it. So you want to be diligent to the best extent you can be.
So I guess the next question is something I would handle is you make a determination of, yes, we need to file a claim. And you went over some of the issues related to joint accounts and who would be related. But once you make the determination to file a claim, the question then is, well, when do we get paid? How do we get paid? And it largely has to do with where you fall in the priority in the order of claims, which that is dictated. It might differ slightly state to state. Generally, unsecured claims are at the bottom, which is tough because you see a lot of other people might be getting paid, the executor, the attorneys who might be handling the work, and you're looking and saying, when do I get paid? In one way, that is from our previous series with regard to collections in general. Filing suit and getting a judgment. A judgment has a higher priority of payment in some states over a unsecured claim. So those will get paid first. Also, there is some differentiation between types of debt and what options you might have. If it's a unsecured loan, a lot of loans have a right to set off in the loan in the event of default. And in almost all loan documents, the default, a death is a default situation. So at that point, if they have other accounts that don't fall into some of the other categories that Andy discussed, you do have the right to go in and set off those funds and recover what you can before the estate even has a chance to handle it. A car loan, similarly, you have the right to declare the loan in default. but you could, at that point, once you declare the loan in default, you can either seek to repossess it, or the other option is have someone come and pay. They might not want the car. They may want to keep the car. At that point, the estate either has to pay your loan off, or they have to get a new loan to come and try and pay off your loan. They just can't keep the car. They can't say, well, he died and he said I could have the car in his will. If there's a balance due on the loan, that's too bad. You got to deal with it. The one issue which we also discussed in one of our previous topics was credit cards. There is no right to set off on credit cards. That's under the federal regulations. You just don't have the right to do it. You have to file a claim against the estate, which is what we just discussed. Was the default is a trigger. Death would be a default, even if they were paying the month before. Death is a default. You just have the option. If you get the judgment, our preference is you get the judgment. It gets treated with higher priority. So, Cam, once we make the determination that we're going to file a claim, how does that process work?
Sure.
In the general concept.
Thank you, Scott. So your first step, once you're dealing with a decedent account, after the review steps that you guys have discussed already, will be to reach out to the court, the appropriate court, where the decedent lived at the time they passed away. Now, depending on the jurisdiction you're in, that court could be called a surrogate court or a probate court, but ultimately that's the correct court you want to reach out to because they're going to have information such as confirmation of the person's passing. They're the court that issues the death certificates Andy mentioned earlier that the family will have copies of, but they'll also be able to answer some basic questions you have and provide some of the forms you're going to need, specifically the claim form that you're going to have to file with the estate and potentially file with the probate court.
So what if the person doesn't actually, or their estate, not the person, they're no longer with us, their estate or whoever is handling their affairs, what if they never actually go to file the necessary paperwork to move forward with probate, but based on public records, information you've obtained, John Smith is no longer with us.
Sure.
What's your recommendation in those situations?
In that situation, you would still want to send a letter to the last known address you have of the decedent, and it would be to the estate of John Smith. But you want to make sure that you're still putting that potential heir on notice of your claim, even if they have not gone through the process of what's called raising an estate with a probate court or surrogate court to get the death certificate issued.
So Cam, you take the steps necessary to send the notice to the administrator or the executor. What happens next?
So that individual, the administrator or executor of the estate, they will then respond to you with either an admission or a denial of the claim.
So then I guess in the event that they deny the claim, at that point, what options do the creditors have if they believe that the claim was improperly denied?
Sure. So a denial of a claim when you're going through a probate process, it's essentially the same as an individual borrower denying the validity of the underlying debt that you're trying to collect on. So what that looks like is what we've talked about in the past in terms of our general legal collection process. At that point, you want to bring a suit. The defendant in that scenario would be the estate of John Smith or whoever your borrower is, but you would then proceed with proving your claim is a valid claim, and you would do it the same way you would any other collection process. You would present evidence of your existing contract, evidence of charges incurred, things like that in order to assert that you have an actual valid claim. Now, the situation could change if there's, say, for example, a denial of a claim that was improper, but also if there was transfers or distributions of property of that estate before your claim was adequately addressed or potentially improperly denied, and then those transfers occurred. In that scenario, you would still proceed with your legal collection process against the estate, as I just described, and as we've talked about in past episodes, but you would also want to consider naming the actual administrator or executor of the estate, because their denial of your claim could be improper, and they could also have engaged in improper conduct by distributing assets or transferring property from the estate without addressing your claim.
And in those cases, the administrator my understanding is they could have some individual personal liability for those
That's
claims.
exactly correct. I mean, that administrator has a duty to handle the estate as though that person were still here, essentially, and take proper steps to ensure fairness amongst all creditors of the estate, and then also the same rules apply to the beneficiaries. So, by simply ignoring or improperly denying a claim that is a valid claim submitted by a creditor, that would be an improper course of action, exposing that administrator or executor to personal liability as well.
And it looks like, as was the case with the previous episodes of What's on Tap, it looks like we have a number of questions coming in. So let's see if we can handle a few of those before our session ends. So the first one I'll handle because it was something I discussed earlier. And the question is, what happens if there's a failure to file a claim within the applicable time limitations? Unfortunately, you're out of luck. If you don't file and you realize in month 11 in New Jersey that you didn't file your claim, too bad. Effectively, the one saving issue might be, or would be, if there is a home ownership situation and you have a judgment, that claim still needs to be paid to clear the title on the property. So at that point, you would still get paid even if you let the estate go. If you don't file the claim, maybe you didn't even know the person was deceased. That does happen from time to time, where you find out well after the fact that they even passed away. Cam, this goes to something you were talking to a moment ago. What if the administrator or executor just doesn't respond to the notice of claim? What are the institution's options at that point?
Sure. At that point, you should really treat a failure to respond the same way you would treat a denial of the claim. But before you go straight into the process of filing a suit, it's something that Andy touched on a little bit before, is really take kind of a practical approach to that scenario. So what I mean by that is failure to respond to a claim could likely be the result of the fact that there is simply no assets in the estate that are actually going to result in a distribution to any creditors or any beneficiaries for that matter.
But
so
they at least have to let you know.
Of course. So they need to let you know. But the only way in that instance to actually find out could be to file a lawsuit or go back to that surrogate court or probate court and continue to monitor for any sort of final accounting that the estate gets filed, showing what distributions occurred or what assets were actually liquidated as part of the estate. So obviously you need to know one way or the other, but before taking the steps to file a lawsuit, take the steps that Andy talked to you about, which is, review the information you have at your fingertips. What assets do you know of for this decedent? What liabilities are actually there? I mean, if we're talking about a $2,000 credit card debt, it may not be worth hiring a Weltman attorney or any other attorney to actually go through that process of litigating against the estate, depending on what you're seeking.
Especially if you see they have a lot of other debts out there, and
Of
if
course.
you're given a percentage interest or a percentage payout, if you're the lowest, is it the cost benefit of, do I hire someone to proceed on a $2,000 bill where I might get $25 based on what else is out there?
Of course, yeah.
And then Andy, one last question. In situations where a person has limited assets, is there any benefit, or I guess the better way to put it, what are the downsides of pursuing someone who has limited assets?
Sure, I think it's been kind of what we've been discussing before, and it's basically there may not be much there for you to collect. So there's no penalties they're going to face, nothing like that. But it's simply there may not be much there, and it just may not be, quite frankly, worth your time or your efforts or your money.
More important,
Your money.
the institution's money.
Yeah, but
Pursue, and how much do you want to throw after a debt that is likely not to be paid?
right, and to your point, it's a business decision.
Yes. So that brings us to the end of this session of What's on Tap. I would like to thank everyone for attending. These have been great sessions, all 5 of them. All attendees, as was the case with previous episodes, you will be entered automatically to win What's on Tap giveaway. Mike has been giving them out all over town, even if marketing folks ask him to stop doing it. If you have submitted any questions that we haven't gotten to, we will certainly do that. As we indicated, we will get them to you as soon as possible. And again, thank you all for your attendance and your contributions through this, and stay tuned for future episodes of What's on Tapped.